Okay, thank you very much. Thank you, Daria, for the invitation to participate in this special issue. We started to craft my presentation in LLRN 2 years ago, in the off LLRN, because there was wine involved in this preparation. And she started to talk about the issue and how fragmentation of labor law would be studied. And in my case, at that time, I was looking at the fragmentation of the regulation of paid domestic work, but then I was analyzing data from a digital platform that I study in Argentina. And then things became complicated, and my approach will be a little bit different of what we saw in other papers, because it's kind of a micro-analyze of how people involved in this labor relation, employers and domestic workers, but also the platform, contribute to mix different normative frameworks and what happened when that uh, uh, happened. I started this research with two friends and colleagues, Francisca Pereira and Ania Tiziani, in 2010. We did 20 in-depth interviews with domestic workers and 2 focus groups with workers and 4 with employers in 22. And also a quantitative survey of 300 cases at the end of the 2020, the beginning of 22. And we have the information about 1,048 jobs positions. And when we analyzed that, we saw that in 48% of jobs mediated by the platform are formal jobs. And when we look at what happened with the jobs mediated by the platform, but that also use the service called Solvers Pagos, that is a service of management of the labor relation, in which the employer give the platform the capacity to formalize the worker, pay the monthly contribution to the social security, do the payroll, and pay the worker. We see that 66% of the jobs are formal jobs. And when we compare that with what happened in the sector, in which only 26% of domestic workers are formal workers, but if we see in the group of workers who work less than 60 hours per week, that is kind of the more typical situation for workers working through the platform, we see that the formalization rate is 16%. And when we saw this graph, we saw, wow, maybe the platform is doing something good, formalizing the labor relation. And the question, the broad question, what happened when the platform intervened? And the approach that I take in this paper is based on the Adele Blackett work, in which she proposed us to think about the government or the governing principles in the sector are in dispute, we will see, between the state law and the law of the household workplace. Looking at the household workplace as this informal, invisible, but very powerful norm in which domestic workers are not considered as workers, but as servants, and there are the denial of all the labor rights attached to the condition of workers. And this tension between these two normative frameworks, it could be seen in every case of in which we analyze paid domestic work. And some institutional scholars like Helm and Levitsky are analyzing this case in terms of how informal institutions change formal institutions. But we could see in the case of paid domestic work going forward between the formal and informal institution. There are influence and changes between that. But what happened when platforms arrive and have their own rules? And these rules are not related to neither rights or cultural perception of paid domestic work. They are related to business. What is the business of the platform and how they can attract clients to use the platform. And I'm focusing on formalization because we saw that the formalization rate within the platform was so impressive that I wanted to know what happened in this configuration that make formalization easier. And the question wasn't the why the labor relation is formalized or not, but the when, because for the why there is many research on that, and I thought that what explain the dynamics of these three different normative logic is when we look at when the labor relation is formalized in the case of domestic work mediated by digital platform. I have to say that the law established that the labor relation must be formalized for the day one. There is no ambiguity on that. And before the domestic worker came to the house, the employer must click something in the tax agency website saying, yes, this worker is legally hired. But it doesn't happen like this. When we see these three different normative logic working together, I thought that there are three dimensions in which this confusion take place. One is the trial period that, like I say, the domestic worker must be formal, and then there is a period in which the labor relation could be dissolved without any consequence. And in the new law that was established, 30 days for full or part-time jobs and 15 working days within 3 months for hourly jobs. And 3 months is the standard trial period for employees in Argentina. And then there is, concerning the law of the household workplace, the time in which the labor relation must be formalized or could be formalized, and it's something very ambiguous, is when the labor relation arrived to, but the personal relation arrived to a point in which the parties feel comfortable enough to establish a labor relation. And in all the stories that I heard from workers and employers, it was like they were talking about marriage. Well, we need to know each other better, to trust, and there is not time for that. But the platform established a new time frame, that is the satisfaction guarantee. It's 30 days in which the employer can replace the worker 4 times. And that's give space for ambiguities and different form of interpretations of the law that is translated in the platform rules and mixed with the law of the household workplace. And in these dynamics, I find 4 cases. The first is what I call the employer's choice, that is most take it from the workers' discourse, in which domestic workers said, well, finally the decision of the formalization is the employer's decision, and we don't have to say in that matter. And that is something that we saw in relation outside the platform. It's not particular for the platform. And then we could say, well, platform intervention don't change anything in that case. Like in the second case, in which the two parties talk about how to build this trustworthy relationship, and a time needed for that is more than 3 months, to give to some people, to some person, the key of your house, or the responsibility to take care of your children. But when the platform intervened is when the trial period became a translation of satisfaction guarantee, kind of a mix or competing meanings of that, and allows employers to say, okay, I cannot formalize someone if I will change that person next week. It doesn't make sense. And there is a trial period, kind of a reinterpretation of this is within the law, but in a kind of ad hoc interpretation of the law. And the fourth position is in which the platform play a role, but not an intended role, we could see, is because the platform offer also what they call the one-time only service, that it was created for business, a small business, or for people who moves and needed to clean the house for 1 day, 8 hours. But employers started to use this service just to try workers. And they told us that is the way to avoid the expectation of a labor relationship. And it's a tool that is an honest way to know someone without give this expectation of a regular labor relation. And we know that not because we believe in CEOs, but because we understood what it was the logic of this platform, and they didn't intend it that this service was used to flexibilize or to give more possibilities to informal and irregular jobs, but it was a service that it was provide, and employers use it regularly in that sense. And just to conclude, what we see in this dynamics is that the overlapping of the different normative logics generates a space of regular ambiguity that is conducive to reinterpretations of the various norms that weaken the power of the state law. Thank you very much.